Welcome to NYPTI's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nypti.com/law to read the full decision.
People v. Mark Smith, decided December 18, 2025. Troutman, J.
Penal Law Section 160.154 imposes criminal liability for first-degree robbery on a person who forcibly steals property and, in the course of the crime or immediate flight therefrom, displays what appears to be a pistol, revolver, rifle, shotgun, machine gun, or other firearm. Penal Law Section 160.102b imposes criminal liability for second-degree robbery on a person who commits that same conduct. However, it is an affirmative defense to the first-degree charge where the object displayed was not a loaded weapon from which a shot, readily capable of producing death or other serious physical injury, could be discharged. Penal Law Section 160.154. Here, we hold that county court properly denied defendant's request to charge the jury on that affirmative defense.
In 2017, a man in a black mask entered a Rochester hair salon and demanded money. An employee testified that as she retrieved cash from a safe, the man held to her head a black object that appeared to be a gun. Two customers also testified that the object appeared to be a gun, although one of those customers, who had a concealed carry permit, could not determine if the object was a play gun or a Glock 9mm. Once the man received the cash, he fled. The police later developed defendant as a suspect based on a Crime Stopper report by an acquaintance to whom defendant had confessed. The acquaintance had bought defendant a BB gun for his birthday. The police executed a search warrant at defendant's home and recovered a black CO2 air pistol and a homemade black mask. Upon his arrest, defendant told the police that they didn't have any evidence. Once informed of the search warrant, however, defendant said, "I'm effed now. They probably found the BB gun in my house." Defendant was charged with robbery in the first degree on the ground that he forcibly stole property and, in the course of the crime, displayed an object appearing to be a firearm. See Penal Law Section 160.154. The case proceeded to trial.
At the charge conference, defendant requested that the jury be charged with the affirmative defense to robbery in the first degree, arguing that the BB gun was not a loaded weapon from which a shot readily capable of producing death or serious injury could be discharged. The people responded that defendant had not presented sufficient evidence to avail himself of the affirmative defense. Defendant argued that a BB gun is not a weapon that can actually shoot you dead. The court replied, "It's a CO2 BB pistol. It's a little different. We are speculating either way." The court denied defendant's request. The appellate division affirmed the judgment of conviction, citing People v. Akinlawan, where the Fourth Department relied on First and Third Department precedent in concluding as a matter of law that a BB gun is readily capable of causing serious physical injury, and thus the affirmative defense applies only when it is demonstrated by a preponderance of the evidence that the BB gun was unloaded or inoperable. See People v. Richard, People v. Padua. We affirm, albeit for different reasons. Contrary to defendant's contention, the court properly denied his request to charge the jury on the affirmative defense. When a defense declared by statute to be an affirmative defense is raised at a trial, the defendant has the burden of establishing such defense by a preponderance of the evidence. Penal Law Section 25.00, Section 2. The court must charge the affirmative defense to robbery in the first degree when, viewing the evidence in the light favorable to the defendant, there is sufficient evidence for the jury to find by a preponderance of the evidence that the elements of the defense are satisfied, i.e., that the object displayed was not a loaded weapon readily capable of producing death or other serious physical injury. People v. Gilliard, see Penal Law Section 160.15, Section 4. BB guns are capable of producing injury, including but not limited to protracted impairment of vision. See Richard. The BB gun was a loaded weapon which discharged a shot that was readily capable of producing serious physical injury. United States v. Shelton. BB guns can cause protracted impairment of a function of a bodily member, such as by blinding, which qualifies as serious physical injury. See People v. Reyes, People v. Hirschhorn. See also Penal Law Section 10.00, Section 10. Whether a particular BB gun is readily capable of doing so is not a question that we can decide as a matter of law. See People v. Hall. Here, although defendant made a prima facie showing that the object he displayed during the robbery was a BB gun that the police recovered from his home, he presented no evidence concerning the capabilities of that particular gun. Given the absence of such evidence, the members of the jury could do no more than speculate that defendant's gun was not readily capable of causing death or other serious physical injury, and thus the court properly denied defendant's request to submit the issue to them. People v. Cottarello, affirming the reversal of a judgment convicting the defendant of first-degree robbery under Penal Law Section 160.153 because there was no witness called to explain the capabilities of a stun gun, requiring the jury to engage in impermissible speculation. Defendant's reliance on equivocal dicta in People v. Howard, 22 NY3D 388, 2013, where we held that defense counsel was not ineffective for failing to seek dismissal of a first-degree robbery charge, is misplaced. Contrary to the dissent, nothing in the language or structure of Penal Law 160.15, Section 4, suggests that it must be read to apply only when the item displayed, which appeared to be a firearm, is not recovered or otherwise known. The dissent goes to great lengths to find a difference between Penal Law 160.15, Section 4, and 160.10, Section 2/B, when the difference between the two sections is self-evident. There is an affirmative defense to the first-degree charge. The dissent's conclusion is, moreover, incompatible with People v. Lopez, in which we upheld a first-degree robbery conviction, where the victim testified that as the defendant announced the robbery, he put his hand in the right side of his vest as if he had a gun. The decisions of Appellate Division, 2nd Department, relied on by the dissent predate Lopez. See People v. Bowman, People v. Jones, with the exception of People v. Layton, which is based on a misreading of the affirmative defense as having been satisfied by evidence that the weapon used in that robbery was not a firearm. Rather, the affirmative defense requires proof that the object displayed was not a loaded weapon from which a shot, readily capable of producing death or other serious physical injury, could be discharged. Penal Law 160.15, Section 4. The text of the statute is clear, and we are bound to give effect to its plain language. See People v. Galindo. The concerns identified in the dissent are properly left to the legislature. See People v. Toledo. If the wording of the statute has created an unintended consequence, it is the prerogative of the legislature, not this court, to correct it, and to the prudent exercise of prosecutorial discretion. See People v. Eberle. We have consistently held that overlapping in criminal statutes and the opportunity for prosecutorial choice they represent is no bar to prosecution. The remaining contentions in defendant's main and pro se supplemental briefs do not require reversal. Accordingly, the order of the Appellate Division should be affirmed. Order affirmed. Opinion by Judge Troutman. Judges Rivera, Garcia, and Canataro concur. Chief Judge Wilson dissents in an opinion in which Judges Singas and Halligan concur. Decided December 18, 2025.
Welcome to NYPTI's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nypti.com/law to read the full decision.